There are jobs that require you to make impossible decisions under impossible conditions with incomplete information on a timeline that allows for none of the deliberation the decision deserves. Social work is one of them. A social worker dealing with child safeguarding faces on a daily basis, a version of the same terrible problem. A family in crisis, evidence that is ambiguous, a child whose safety depends on a decision that must be made now, and the knowledge that getting it wrong in one direction means a child stays in danger, and getting it wrong in the other direction means a family is destroyed. There is no good outcome available in many of these situations. There is only the least bad one. And the person who makes that decision, who goes through the file, makes the judgment call, signs the paperwork, is the person who carries it. Patricia Osei had carried those decisions for 19 years. She was a senior child protection social worker for a London Borough Council, the kind of professional who is called in when the cases are most complex and the stakes are highest. She had made hundreds of decisions over 19 years. Most of them had been right. Several had been wrong in the inevitable way of a job where some percentage of wrong is unavoidable. In 2016, she was convicted of gross negligence causing death. A child had died. The child had been on her caseload. She had made a professional judgment 3 weeks before the death that the child could remain safely with the family under a protection plan. That judgment, in retrospect, had been wrong. But in retrospect is not the standard to which a social worker is held. In retrospect, hindsight, the clarity of knowing what happened, makes decisions that were reasonable in context appear unreasonable in outcome. And the distance between those two things is where Patricia Osei spent 3 years of her life. This is the story of what happens when a system that consistently fails to provide adequate resources, staffing, or support then criminalizes the individuals who make decisions within those constraints, and of the particular cruelty of prosecuting a person for the systemic failure that surrounded them. Patricia Osei had come to social work through a route that many child protection workers share, a combination of personal history and principled response to it. She had grown up in South London, the daughter of Ghanaian parents, in a household that was stable and loving, but in a neighborhood where she had seen, from childhood, what happened when families fell apart without support. She had decided at 17 that she was going to be part of the system that provided that support. She had studied social work at Goldsmiths, University of London, qualified at 22, and spent 19 years working for the same London Borough Council, progressing from a newly qualified worker handling straightforward family support cases to a senior practitioner managing the most complex child protection cases in the borough. She was known by colleagues as thorough, careful, and deeply committed to the families she worked with, committed in the specific way that distinguishes social workers who see the people in their files as people, not as cases. She was also known as someone who advocated consistently for her caseload, who raised concerns about resource levels, about the number of families she was expected to manage, about the support available to families at risk. In 2015, she was managing 26 active child protection cases simultaneously. The recommended maximum, by the standards of the profession, was between 12 and 15. She had raised this with her management twice. She had been told that the borough was working on recruitment and that she should prioritize. The family at the center of what happened had been on her caseload for 8 months. A mother in her mid-20s, struggling with mental health difficulties and domestic violence history. 2 children, a 4-year-old girl and an infant boy. The father had a history of violence and had been the subject of an occupation order. Patricia had visited the family 4 times in 8 months. She had arranged support services. She had put the family on an enhanced protection plan. She had, 3 weeks before the infant boy died, made a judgment, based on her most recent visit and the information available to her, that the immediate risk was manageable within the existing plan. The infant boy died on a Friday morning in February 2016. He was 4 months old. The cause of death was determined to be non-accidental head injury, injuries consistent with violent shaking. The father, who had been present in the flat despite the occupation order, was arrested. He was convicted of manslaughter in a separate criminal proceeding and is currently serving a sentence. A serious case review was commissioned by the local Safeguarding Children Board, a standard process following a child death in circumstances where child protection services had been involved. The review examined the actions of all agencies involved: social services, health visitors, general practitioners, and the police. The review identified a number of practice issues across multiple agencies. It noted the high caseload Patricia had been managing. It noted that the home visit 3 weeks before the death had assessed risk as manageable. It noted that the father's presence in the property, in breach of the occupation order, had not been detected. The review's conclusion was that this was a case of systemic failure across multiple agencies, with individual practice issues that should be addressed through professional development and supervision rather than criminal prosecution. The Crown Prosecution Service reached a different conclusion. The CPS reviewed the case and decided to charge Patricia Osei with gross negligence manslaughter, the same charge applied to medical professionals whose errors caused death. The theory was that Patricia's decision to assess the risk as manageable 3 weeks before the infant's death constituted gross negligence that had contributed to the death. Patricia's colleagues, her union, and the social work profession responded with something approaching collective horror. The charge of gross negligence manslaughter for a professional judgment made in good faith, under documented impossible conditions, with the information available at the time, was, in the view of most child protection professionals, a criminalization of social work practice that would make the profession impossible to carry out. The CPS proceeded regardless. The trial of Patricia Osei opened at the Old Bailey in September 2017. It lasted 5 weeks. The prosecution's case rested on the argument that Patricia's assessment of risk 3 weeks before the infant's death had fallen so far below the standard of a reasonably competent child protection social worker as to constitute gross negligence. They presented expert evidence from a social work academic who testified that the available information should have led Patricia to escalate the case to a higher level of intervention rather than maintain the existing plan. The defense presented the reality of Patricia's working conditions, the 26 cases, the documented requests for support, the resource constraints that the council had been warned about, and argued that her decision had been reasonable given what she knew and the context in which she was working. They presented expert evidence from 2 senior child protection practitioners who testified that Patricia's assessment was within the range of reasonable professional judgment. They also presented evidence that the serious case review had specifically found that the failure was systemic rather than individual, that multiple agencies across the system had missed opportunities, and that to isolate Patricia's decision as the single point of criminal failure was to misrepresent what had happened. The prosecution's expert acknowledged the systemic context. He said, "The systemic failures are real. They are relevant. But a social worker with Patricia's experience should have recognized the escalating risk regardless of caseload pressure. The standard of care required by gross negligence is not reduced by resource constraints." This is a legal argument. It is also a philosophical one. The standard of care that the law requires does not bend to the resource environment in which care is delivered. Patricia was being judged against the standard of what a competent social worker would do, not the standard of what a competent social worker with 26 cases and insufficient support would do. The jury deliberated for 6 days. They found Patricia Osei guilty of gross negligence manslaughter. She was sentenced to 3 years in prison. She was 47 years old. She had spent 19 years in a job that asked the impossible and then been convicted for failing to achieve it. Patricia Osei entered HMP Wrongful in Surrey in October 2017. She was the first social worker in England and Wales to be convicted of gross negligence manslaughter for a child death on their caseload. This distinction was not one she had sought. It meant that her case became, from the moment of her conviction, a focal point for a debate about the criminalization of professional judgment that extended far beyond her individual situation. Social work unions, professional bodies, and academic researchers argued consistently and publicly that the prosecution had been misconceived, that the standard applied to Patricia was inconsistent with the working conditions in which she had been required to operate, and that the conviction would deter qualified social workers from working in child protection, worsening the very resource crisis that had contributed to the death it was meant to address. Several studies conducted in the 3 years following Patricia's conviction documented a significant increase in the number of social workers leaving child protection roles. Managers in the field reported difficulty recruiting experienced workers to complex cases. The conviction had, in the view of many professionals, produced exactly the effect that the social work community had warned it would. Patricia was aware of all of this. She followed it from inside, through the legal correspondence her solicitor brought, through the reports that her husband, James, brought on visits. James visited every week. He had been her husband for 21 years. He was a secondary school teacher. He brought her books and news and the reports of a debate that was happening in the world about whether she should ever have been in prison at all. She participated in that debate from inside through her solicitor. She provided detailed written accounts of her working conditions, her caseload, and the professional context of her decision. She submitted evidence to a parliamentary inquiry into the criminalization of social work that was convened in 2018. Her submission was cited in the inquiry's report. Patricia's appeal was heard by the Court of Appeal in November 2019. The appeal rested on two grounds. The first ground was that the trial judge's direction to the jury on the legal standard of gross negligence had been inadequate. Specifically, that the judge had not directed the jury to consider whether the systemic context in which Patricia worked was relevant to the assessment of whether her conduct fell so far below the standard of a reasonably competent social worker as to be criminal. The second ground was that the prosecution's expert witness had applied a standard that did not adequately account for the resource environment. The expert had testified about what a competent social worker would do, a standard calibrated against an ideal of practice that bore no relationship to the conditions Patricia had been working in. The Court of Appeal heard detailed submissions from both sides. They also received, as intervening parties, written submissions from two social work professional bodies and from a child law academic consortium, an unusual step that reflected the broader significance of the case for the profession. The court's judgment, delivered in February 2020, quashed the conviction on the first ground. The court found that the trial judge had failed to adequately direct the jury on the relevance of systemic context to the assessment of gross negligence. That the jury had been left to apply a standard that was abstracted from the real conditions of the defendant's work in a way that was legally incorrect. That a properly directed jury, instructed to consider the full professional context, might have reached a different verdict. The court did not hold that Patricia had been innocent. It held that the conviction was unsafe. There is a distinction, a painful one, between those two things. The CPS reviewed the case. They decided, after careful consideration, not to retry. They cited the time elapsed, the nature of the new evidence, and the public interest in not prolonging proceedings that had already had significant professional consequences. Patricia Osei's conviction was quashed. She had served 2 years and 4 months. Patricia Osei's exoneration did not end the debate her conviction had started. In some ways it intensified it. The Court of Appeal's judgment had quashed the conviction on procedural grounds, the misdirection of the jury, without addressing the fundamental question of whether it should ever have been possible to prosecute a social worker for gross negligence manslaughter in circumstances like Patricia's. That question remained open. The Parliamentary Inquiry's report, published in 2019, had recommended legislative changes to clarify the circumstances under which child protection professionals could be subject to criminal prosecution. It recommended that systemic context, caseload, resources, supervision, should be a statutory consideration in any gross negligence manslaughter prosecution involving child protection workers. The recommendation had not, by the time of Patricia's exoneration, been implemented. Patricia became, in the months after her release, a central voice in the push for those legislative changes. She spoke at conferences. She gave evidence to a further parliamentary committee. She wrote an extended personal account that was published in a social work journal and that was cited in academic literature on the criminalization of professional practice. She said in that account, "The child who died deserved better than what the system gave him. His family deserved better. What they received was a set of services operating under impossible strain, staffed by people who were trying to do the right thing with inadequate resources and inadequate support. I made a judgment. The judgment was wrong. But the circumstances that produced the judgment were not mine alone." She paused. Then she said, "The question I keep asking is whether criminalizing that judgment made a single child safer. Whether it improved the system that produced the conditions. The evidence says it made things worse. Experienced workers left. Cases went unallocated. The system became more dangerous because the prosecution made it so. The infant boy who died in February 2016 was real. His name is not used in this account, in keeping with the convention of not naming child victims, but he was real, and his death was real, and his family's grief was real, and nothing in Patricia Osei's exoneration changes that. His father, who killed him, is in prison. That is the direct accountability for his death. The council that failed to address the staffing crisis, the management that did not act on Patricia's documented requests for support, the system that distributed 26 cases to a single social worker. These things have faced no criminal accountability. The council was subject to a statutory inspection following the death. It received an improvement notice. It produced an improvement plan. These are administrative consequences, not criminal ones. Patricia Osei received compensation from the government for her wrongful conviction. The amount has not been disclosed. She has not returned to child protection social work. She says the work is necessary and important, and she believes in it deeply. And she also knows that she cannot do it again in the current environment, that the environment that produced the conditions of her case has not changed enough. She works now as a trainer and consultant to local authorities on child protection governance, helping councils understand and manage their statutory responsibilities, advocating for the resource levels that the work actually requires. The legislative changes recommended by the parliamentary inquiry have not yet been passed. Patricia continues to advocate for them. She was asked, in a recent interview, what she thought about the system that had employed her for 19 years and then prosecuted her. She said, "I don't think about it as the system. I think about the people in it, the workers, the managers, the children, the families. The system is what we make it. We made it too small for what it was being asked to do. And then when it failed, we blamed the person inside it rather than the size." She said, "I still believe in the work. I still believe that child protection social work, properly resourced and properly supported, is one of the most important things a society can do. I believe in it enough to have given it 19 years. She paused. She said, "The question is whether we believe in it enough to fund it properly, to staff it adequately, to support the people who do it, to treat them as professionals making difficult decisions under impossible circumstances, rather than criminals when those decisions go wrong." She said, "That is the only question. Everything else follows from the answer to that one."